Hello, my name is Julia Reda. I'm a member of the European Parliament, and for the last 5 years, my main work has been to work on copyright reform. The copyright reform that the European Union is working on at the moment could have a devastating effect for the global internet ecosystem and the way that copyright is going to develop globally. So I think it's very important that people all over the world are aware of this development that is unfolding in the next few days, know what we can do to stop the most dangerous elements of this proposal, and be aware that if we fail to do that, the same proposals that we are seeing in Europe today have a danger of proliferating all over the world. So I'm very glad to be able to be talking to you at the Australian Digital Alliance. I know that in Australia there have been many efforts to have a positive copyright reform that would follow up with some of the positive ideas that already exist in other jurisdictions. But we have to be very careful that the global copyright reform direction does not take a spin that will make the internet less free for everybody around the world. The most important element of the ability for the global internet ecosystem to have developed the way it has in the last couple of years is probably the safe harbor, which is a system that exists in different ways in different jurisdictions. In the United States, you have the Digital Millennium Copyright Act, which says that online platforms are not directly liable for copyright infringements by their users, provided that they act expeditiously and remove copyright infringement when they gain knowledge of it. The same system exists in Europe under the e-commerce directive. And this safe harbor is what has made the internet more than just a playground for a few geeks and internet experts, and more than just cable television where you have a small number of gatekeepers that tell us what we can see. With the safe harbor and the ability for online platforms to provide to everyday internet users the possibility to broadcast their own creativity without having to have the knowledge to build a website for themselves or anything like that, it is possible on these platforms to express yourself and to find relatively broad audiences, even if you're not connected to a media company, be it a publisher, a music label, or a TV broadcasting company. So this has really revolutionized the way that we communicate on the web. And I think overall, this has been a really positive development. It has allowed marginalized communities to find a voice online. It has allowed independent artists to make a breakthrough. And even if there are some negative aspects of these online platforms, we would not know where we would be today if this really democratic and open form of communication were not available. This expression for everyone has really been a radical democratization and explosion of creative productivity online, that there is room for niche art, there is room for people to build an audience by themselves and remain economically independent. The European copyright debate about platforms has sounded quite different in recent years. There is a lot of uneasiness about the fact that these safe harbors are available to companies that have grown quite large. And in the European discussion, they are quite often summarized under the acronym Gotha, which stands for Google, Apple, Facebook, and Amazon, which are, of course, companies that are quite different and have different business models. But all of them have benefited from the internet and have grown to be large global players in the last decade or so. So nowadays, a lot of the creative activity that is happening online is happening on these major platforms, but of course not all of it. There is also an ecosystem of many smaller platforms that may be new and that may not be as well known, especially to politicians. And of course, a lot of the criticisms that is labeled at these large online platforms is perfectly justified, be it criticism that they don't pay enough taxes, concerns around data protection, concerns about the mere size of these companies. And I don't want to downplay these absolutely legitimate concerns in any way. But if you look at the copyright discussion in Europe, you get the impression that these four companies are treated like the four horsemen of the apocalypse, that basically any measure that is expected to be negative for these companies is supposed to be automatically positive for the internet and society at large. And unfortunately, the concerns that people have about these companies that should be addressed are not in the area of copyright. So the copyright debate has been hijacked by a number of already large media companies, many of which are based in Europe, to take the legitimate grievances about online platforms and channel them into being able to lobby for copyright legislation that is in the interest of already existing legacy media companies, and being able to justify them by saying that they are somehow against the large worldwide internet platforms. Unfortunately, this is really not a very productive approach to copyright law, because there is a very urgent need of reforming copyright law and updating it to the internet environment, except that it has to be done in a completely different way than what we are seeing in this European copyright proposal today. The core development that has changed the way that copyright is applied through the development of digital technology is that today, every person who has a smartphone is a right holder. To take Germany as an example, every single picture that is taken is protected under German copyright law. It's copyright protected if it is a creative work, so it's protected for 70 years after the death of the photographer. And even if it's not a creative work, if it's just a snapshot, a selfie, it still gets a protection of 50 years after publication. So that means that literally every single person who has been using a smartphone and perhaps publishing it on their pictures on their Facebook account is not just a right holder, but is a published right holder, and who has claims against anyone in the world who might be using those photographs. And this is, of course, a situation that copyright law is not prepared for. Copyright law was designed to deal with a relatively limited number of right holders. On the one hand, the people who actually publish their art and make it available to audiences commercially, and on the other hand, a relatively limited number of exploiters, so those who are selling books, let's say. And on the internet, the situation is the exact opposite. Everybody is a copyright holder, and also everybody is breaking copyright law in their everyday interactions on the internet. A lot of internet culture, pop culture that has been around for centuries, let's say, where you take somebody else's work and create something new out of it, you expand on a fairy tale that has been passed on from generation to generation. On the internet, all of this happens in the form of a publication, something that is enshrined as a digital file for future generations, and therefore also completely falling under existing copyright law. This includes memes, reaction GIFs, lip dubs, let's play videos, all these kinds of things that absolutely do not hurt the commercial interests of any right holders. Often to the contrary, like nobody stops going to the movies because they have seen a 3-second reaction GIF, but nevertheless, all of this is copyright infringement. So what a reasonable and progressive copyright law should be doing is to have debates about how do we reconcile copyright law with these absolutely fundamental changes that have happened through the internet and the broad introduction of digital technology in society. So what we should be having debates about is, don't we need a mandatory registration of copyright in the same way that we have a register for patents or trademarks, to say that copyright no longer fully applies automatically at the moment that you create something, but that you rather have a kind of Creative Commons type, some rights reserved, for all cases, but the full exclusive rights attached to copyright that are mostly interesting for people who commercially create something should be limited to those people who actually want it and who actively register their work with a copyright register. Currently, this is not possible under international law because the Berne Convention forbids any kind of formalities that require an author to register their copyright. But we also have to recognize that these international rules stem from the 19th century, when nobody knew how easy it would be to register something globally because the internet just wasn't around yet. Similarly, we should be talking about things like fair use in jurisdictions that do not have it yet. So in Australia, this is an important debate. And also in Europe, we still have the problem that the European Union does not have a harmonized set of copyright exceptions. So every one of the 28 countries in the European Union has its own national copyright law. None of them have fair use. Instead, you have specific exceptions for very specific purposes. For example, freedom of panorama, which allows you to take pictures of art in public places. The problem is every country deals with it differently. And if you look at just the German-speaking area, where you have Germany as one jurisdiction and Austria as another, both of them have the same language, they share the same media to a large extent, but they have different copyright laws with different, very narrow copyright exceptions. So that, for example, if you photograph an artistic building in Austria, you are allowed to do so from a private building, provided that the thing that you are photographing is in the public space. Whereas under German law, what matters is whether the photographer is standing in a public space when they see the thing that they are photographing. So basically, the lack of a European fair use system is what is making copyright law on the internet so complicated. And unfortunately, we are not discussing in this copyright reform to introduce fair use into European law and to make all the copyright exceptions mandatory, but instead we are working on things that might actually make the difficulties with copyright on the internet even worse. The EU copyright reform was proposed in 2016 and is now just a few days away from its possible adoption. It has not addressed these really pressing problems that we have with EU copyright law, updating it to the digital age and making sure that the same copyright applies in all 28 EU countries. What is being dealt with in this copyright reform is a kind of industrial policy where the EU is trying to strengthen those companies that are already big in the EU and trying to distribute money from the large, mostly American internet companies and put it into the pockets of large European companies. So in a way, instead of reforming copyright law and making it worse, in making it better, the purpose of this directive seems to be to pick a side in a fight between two very large industries. So Europe does have large press publishing houses, it does have large media companies in the area of television, it does have large music producers, and this is where this directive is putting its focus. The effect of that is that the most controversial provision of this proposal, Article 13, threatens to undermine the core of what has made the internet flourish worldwide in the first place. It is stripping online platforms of the safe harbor that makes them not directly responsible for copyright infringements of their users. And in a way, it tries to return to an old system of cultural creation where you have professional, organized creators on the one hand, and unique gatekeepers, so producers like publishers and TV companies on the other side. The effect of this would be that the internet would be turned more into cable television, where not anybody can produce, but only consume what other people have curated and chosen for them. Those platforms that have already grown to be big, like Google or Facebook, would probably not perish under these new rules, but rather would be forced to make direct agreements with a small number of really large rights holders organizations. And they would have to take much stricter control over what is published on those platforms. So once again, we would have a situation where there is a central control over the programming, over the art that is available to large audiences on the internet. The barriers to new platforms that could one day grow up to be a competition to those existing internet platforms would be huge, and new entries into the market from Europe would probably be out of the question. And what will definitely suffer is the diversity of online platforms and also of internet content that is available to people, because a lot of the politicians that are writing these laws are only aware of Google and Facebook. They have never heard of Reddit, of DeviantArt, of some of the European platforms that we have that allow artists to actually make money with the works that they upload there voluntarily. So how exactly does Article 13 work? Article 13, first of all, defines a new category of hosting providers. So it applies to hosting providers that are online platforms, so users can upload material there. They host large amounts of copyright protected content, and this is important. It doesn't say large amounts of copyright infringements, it says large amounts of protected content. And as I said earlier, every picture is protected in some European jurisdictions. So in other words, any platform that has a large number of pictures that is also a profit-making company is potentially covered by these rules. So this would also include image boards, discussion forums that actually are used for a very specific purpose. Let's say a social media company that is catering to a niche interest might still have large amounts of pictures. There are social media companies, for example, that create communities for people who like to go fishing. And of course, they upload their pictures of their catch to those platforms. But just because these platforms have large amounts of copyright protected content, namely the pictures that are uploaded there, that does not mean that they are actually exploiting authors. Nevertheless, all of these commercial platforms that have large amounts of copyright protected content are covered under Article 13. And for those platforms, the safe harbor protection from liability for the copyright infringements of users is removed. In order to avoid this liability, they have to fulfill two criteria. The first one is that they have to make best efforts to get licenses from right holders. Unfortunately, Article 13 does not in any way limit this obligation, let's say, to the right holders who actually ask for a license. No, it says you are liable for the copyrighted content that is uploaded to your platform unless you have tried to get a license for it. Of course, the platforms don't know what copyrighted content the users are going to upload in the future, let alone who the actual right holder is. Let's say I draw a picture like the one on this slide, I send it to you and you upload it to Flickr. How is Flickr supposed to know who they are going to negotiate a license with? But this is a mandatory obligation. You have to show that you have tried to get a license in order to be limited in your liability. But of course, the right holders, even if you have found them, are not required to actually offer you a license. So in other words, if they say no, and they ask you instead to make sure that the content cannot be uploaded to the platform, you have to prevent the upload from happening in the first place. Of course, this can only be done through upload filters, which is the main point that has gained public attention in the criticism of Article 13, is that an infrastructure of upload filters would become mandatory for a really broad range of online platforms. Article 13 says that on top of trying to get a license for everything that is uploaded, you have to filter the content according to high industry standards whenever the right holder asks you to. So the only exception for this filtering obligation is for small platforms that are also younger than 3 years old. So this is supposed to be a nod to European startup companies, but of course there are many small discussion forums, small companies that have no intention of ever growing large, that will also not be able to pay the cost of such costly upload filters that on top of that make a lot of mistakes. We already know Content ID, which is the upload filter used by YouTube, which is geared towards a relatively small number of copyrighted material, primarily music and video recordings. But Article 13 would actually require online platforms to try to prevent the upload of any copyrighted work that is notified to them by right holders. It doesn't have to be music or video, where at least there are some technological possibilities, as faulty as they are, but the same would apply to a poem, to software code, to a character from a novel, to architecture, where it is much less obvious to see how you could automatically prevent the upload of such material. So the likely effect that Article 13 would have is that the users who upload copyrighted material, which is often created by themselves, is that they will be guilty until proven innocent. The upload filters that we know don't actually check whether something is a copyright infringement or not. They just check whether registered copyrighted material is present in the material that is uploaded. So that means that all the copyright exceptions that we have in European law, as fragmented as they are today, let's say the right to quotation, the right to parody, are threatened by these mandatory upload filters, because whenever they detect that registered copyright material is present, they will, when in doubt, simply block it. And then you have to complain to say that actually the content that you uploaded was legal. But let's say there is a parody exception in a country that covers, for example, memes. It's very difficult to believe that a user who is able to upload a meme legally would go through the trouble of going through a dispute resolution mechanism to try to prove that they were allowed to upload a meme, because it's simply not worth the effort in many cases. Similarly, if you have a live stream, for example, it is not worth anything to have your content unblocked 24 hours later, just because, let's say, there was some music playing in the background in the place where you were doing the live stream. So I think the effect would be that the default would not be that expression on the internet is allowed, but the default is that expression is forbidden, and you have to prove that you are allowed to do certain things under a copyright exception. This is why, for example, the UN Special Rapporteur for Freedom of Expression has warned against this proposal, because he says that it would limit the ability for people to benefit from copyright exceptions. Also, the German Data Protection Authority has raised grave concerns because, of course, not every platform is going to develop its own upload filter, but rather it's likely going to be, again, a small number of large technology companies that have the possibility to develop this technology and then license it to everybody else. Most likely, not every online platform is even going to host their own filtering technology, but rather send all of their internet traffic through the servers of those companies that provide the filtering technology. And once again, you would actually be reinforcing some of the near monopolies that we have in the platform market and put more personal data in the hands of companies. So why is this happening? Why is the European legislator so out of touch with the changes that we actually need in copyright law? It's not just that the law hasn't caught up to the explosion of creativity that we see on the internet and has not found a way to actually help this creation become sustainable, rather than trying to limit it and go back to the age of television. I think the reason for that is that it's not just the law that is the problem, but also the politicians who are making the law are not actually in touch with the developments that we see on the internet. Article 13 only makes sense and only does not seem completely confusing and pointless, as it seems to all the experts, if you are in a mindset where you only know YouTube as an example of an online platform. You don't use Tinder, TripAdvisor, Reddit, or any of these other platforms. For you, the internet is basically YouTube and Facebook. It only makes sense if you only think of those creators as copyright holders who are a member of a collecting society or have a deal with a large media company. And it only makes sense if you think that those collecting societies and media companies, of which there is a reasonably small number, are able to license all of the copyrighted content in the world, which actually they cannot. The vast majority of copyright holders today is not a professional creator. They do not have deals with record companies or publishers, and they certainly are not members of collecting societies. So all the approaches that we have had in copyright law in the past that could deal with this situation are just not up to the task. And the leading politician who has been ushering this proposal through the European Parliament in the last years is Axel Voss, a Christian Democrat from Germany. And some of the statements that he has made publicly, I think very well show the misunderstanding that is underlying this proposal. So Axel Voss has said that if the intention of a platform is to give people access to copyright protected works, then we have to think about whether this kind of business should exist. So he is probably talking about YouTube in this quote, but what is really striking is that he is not saying companies that build their business model on copyright infringement should not exist, or companies that exploit authors should not exist, but he's talking about platforms that give people access to copyright protected works. And he does not seem to understand that pretty much anything is copyright protected or protected by neighboring rights, and that quite often the original authors, the rights holders, are the ones who voluntarily upload their works to those platforms. Take Tinder as a dating platform as an example. Of course, Tinder makes money from giving people access to pictures, but it does not do so by encouraging copyright infringement. Tinder has no interest in people uploading pictures for which they don't have the rights. And it also does not exploit photographers through its business model. So this is a fundamental misunderstanding that basically online platforms that are based on copyrighted material or user uploaded content are necessarily a threat to the livelihoods of creators. Another misunderstanding, I think, relates to the belief in what filtering technology actually can do today. So Axel Voss has also said that if you enter memes into Google search, you do get a page full of memes. So apparently, Google is able to recognize the difference between a meme, let's say a parody, and a copyright infringement. And of course, the fact that you receive these memes in search is because of metadata that identifies the content as memes, and not because there is an artificial intelligence algorithm analyzing the content of pictures and deciding whether it's a parody or not. So until artificial intelligence has developed a sense of humor and has achieved a law degree that allows it to appreciate the subtle differences between copyright jurisdictions in the EU, it will not be able to distinguish whether something is a copyright infringement or a legal parody under the exception for parody, caricature, and pastiche. But it is not a coincidence that people like Axel Voss, who are in charge of writing these laws, have this almost childlike belief in the ability of technology, because there are lobbying companies that are directly spreading these rumors. GEMA is the German collecting society for music authors and music publishers, and they have said that artificial intelligence can recognize faces, it can filter preferences, and even park a car. And therefore, it should be easy to distinguish between an original and a parody. Of course, they are not mentioning that these algorithms are extremely expensive and are cutting edge. And it also does not understand that these are very different problems to solve, where one is about recognizing parameters and matching patterns, something that algorithms are relatively good at. And on the other hand, in the case of distinguishing original and parody, it is about appreciating art. In order to decide whether something is an original creation in the first place, you have to know what is considered artistic creation. And in order to distinguish parody, you have to understand humor. So these are much more difficult problems. So the underlying assumption leads to a situation where the European lawmakers basically look at YouTube as a competitor of Spotify. They both allow people to listen to music, and one is paying more to right holders than the other. Therefore, there must be a problem. What they envision YouTube to be is basically a kind of SpottyTube where you broadcast only licensed content. So it's kind of a crowdsourced Spotify where users upload copyright protected music from the large music labels, and then YouTube makes its money off that. Of course, what this very limited narrative of what YouTube does misses is that most of the expression that happens on YouTube is not an upload of a music video or an upload of a Hollywood blockbuster, but it's people filming themselves or making transformative uses, creating something new. And there's an entire ecosystem of YouTube creators that European politicians are suddenly learning about that have audiences of hundreds of thousands, sometimes even millions, that create content themselves and are in a continuous conversations with their viewers and with users who respond to them, and are actually now also talking about the copyright reform, obviously, because this is something that is directly threatening them in their own creation and in their livelihoods. And sometimes I get the impression that Axel Voss and other politicians who support Article 13 think that YouTubers are employees of YouTube and that basically YouTube works like a traditional TV company. So this is the narrative and this is the misunderstanding that we are up against in this fight about the copyright reform in Europe today. Of course, this is not an entirely new fight, but rather Article 13 is part of a long history of attempts by politicians to use copyright law to undermine the free expression on the internet and to turn the internet into a much more controlled space with a small number of gatekeepers. This history includes deep packet inspection, which was mostly an idea against file sharers to force internet service providers to spy on their users to be able to identify file sharing traffic and block it. It included the 3 strikes law, which was a proposal to block people from access to the internet if they have infringed copyright 3 times, which is nowadays really a crazy idea because nowadays we recognize that access to the internet is important for people to be able to exercise their human rights, freedom of education, freedom of information and expression, and because we also recognize that everybody infringes copyright all the time, and even state institutions and large companies are not able to avoid breaking copyright rules 3 times. There was also ACTA, an international trade agreement that was voted down by the European Parliament in 2012 over threatening to have stricter copyright enforcement. Around the same time, SOPA and PIPA were rejected in the United States. So all these proposals were eventually defeated, and in a few days, we will know whether the internet community was able to defeat Article 13 as well. There was already a vote in the European Parliament over this copyright proposal in July of 2018. And back then, the first draft of Article 13 was rejected by the European Parliament. So there is some hope that this defeat of Article 13 would be repeated. However, after the vote in July, the proponents of Article 13 did not seek to engage with the critics, which also included a lot of academics who were saying that Article 13 just does not work, would create a censorship infrastructure and would not actually lead to fair payment of authors. They did not do that. They did not try to rework Article 13 to turn it into something that could actually work. Instead, the proponents of Article 13 started attacking the critics. Back in July, when the European Parliament first voted against Article 13, a lot of people had been reaching out to their members of parliament by email, asking them to vote against the proposal. The copyright industries in Europe were very successful in convincing parliamentarians that these emails had been generated by bots, that they were not written by real people, but that there was a conspiracy of large American internet platforms who had orchestrated a sort of fake protest. Well, now, a few days before the final vote on Article 13, we know how fake this protest was, because for almost a month now, people have been taking to the streets in Europe, especially in Germany, every weekend and sometimes also during the week. And one of their main slogans has been, "We are not bots." People are really upset about the fact that European politicians have been misled to believe that this protest was fake, that it was orchestrated by large companies. What they are showing every weekend on the streets is that there is an entire generation who expects politicians to reject Article 13 and to maintain the internet ecosystem that they have grown up with, and that is a really important part of their lives. The protests are expected to culminate in a final European protest day happening on the 23rd of March, which is one of the reasons why I cannot be in Australia in person. We expect the largest protest to happen in Berlin, where there has been really an extremely lively discussion about this, to the point where Angela Merkel has had to make statements about criticism on upload filters. And the German Justice Minister, who is actually responsible for copyright law, has said publicly that she thinks Article 13 should be deleted, while still voting for it at a European level. So this is a fight that is really far from over, and whether or not we will be able to win it will depend quite a lot on the strength of the protests that are happening on the streets on the 23rd of March. This protest is really led by a young generation that is extremely upset that the criticism that has been leveled against Article 13 for years by experts, by academics, and by the general public has been completely ignored. And instead of trying to find a fair compromise for all sides, the proponents of Article 13 have doubled down on their demand and have really completely discredited anyone who is against Article 13. And we hope that this anger is something that can be channeled into a positive moment, where once again the European Parliament stands up as the directly elected representation of the people, the way that it did when it rejected ACTA, and votes down this proposal next week in the final vote. The stakes in this final vote, which is expected to happen on the 26th or 27th of March, so Tuesday or Wednesday next week, these stakes could not be higher. Globally, this reform is extremely crucial, and we have to make sure that Article 13 fails. This is the only way that politicians will be forced to listen to the absolutely valid criticism that copyright law, the way that it works today, is not compatible with a communication on the internet, that it is hurting a lot of the rights holders that it is supposed to protect, because it cannot deal with the fact that everyone is a creator and everyone is a right holder today. When the final vote happens, if Article 13 is adopted, this directive will be sent to the national governments all over Europe, who have to transpose it into their national laws, and they will have 2 years to do so. And that is actually a big problem, because it will mean that the adoption of the copyright directive would be celebrated as a huge success. Europe being able to stick it to the large online platforms, and it could be celebrated as the role model for the rest of the world and the blueprint for the development of copyright in other places around the world. But we will only see the negative consequences of this law 2 years later, when it may be too late for other places around the world to reverse the course of their decisions. We're already seeing today that, for example, in the United States, the US Copyright Office is looking with great interest at the discussions around Article 13. And of course, in Australia, online platforms have been living with the uncertainty of not having a clear safe harbor protection and trying basically to follow the laws in other places of the world, like the US DMCA, to show that they are trying what they can to avoid copyright infringement. And it's really important that safe harbor protection is something that applies throughout the world. And if Europe gets rid of it now, it could be the beginning of the end of safe harbor. So it's really important that we get rid of it now, and we have a really good chance of doing so because the public reaction against Article 13 has been overwhelmingly negative, and we have not seen such large protests around an internet topic since ACTA in 2012. What is at stake at the end of the day is not just saving the internet from becoming cable television once more, but it's actually also about saving the trust of an entire generation into the EU democratic process. These are people who are voting for the first time in 2019 when we have the European elections in May, and there are people who have grown up with the internet, and basically every person below the age of 30 in Germany for sure knows what Article 13 is and is worried about it. So it's extremely important that we don't disappoint this generation who would like to see a democratically elected parliament stand up for their rights and not just take the perspective of a generation that is not really using the internet on a daily basis. So this is what I have to say. I look forward to discussing with you further what we can do to stop Article 13. And I can only stress that this is one of the most important votes for the future of the internet worldwide. Thank you.